great. Well, good morning, everybody, and welcome to the last My Story in this series, but obviously we will return with many more people to share their story and their interests on Sunday morning later in the year. It's an absolute privilege to welcome Charles Corman to talk to us this morning. Charles is a long-standing member, a very important member of South Hampstead community, and he'll talk to us about his life in the law, 7 decades in the legal profession. So Charles, over to you. A big welcome.
Thank you, Lawrence. And first of all, a very warm thank you to you and to Gillian for all the two of you have done in organizing these talks. And they have done so much to help our spirits in these rather uncertain times. Thank you very much for that. I've headed my talk, I've titled it Tales Out of Court. My introduction to the legal profession was rather bizarre. It was September 1955, and I had just graduated from UCL, and I was about to start my articles with the law firm of Titmus, Sainer and Webb. I know that it was usual, probably still is usual, for parents to accompany their children on their first day of school, but I did not expect that my father would be coming with me on my first day at the office. However, he was with me to deal with the important requirement for the payment of the premium for my articles. The amount, believe it or not, was £500, the equivalent today of £14,000. My father handed over the check to Leonard Sainer, the senior partner, and I was left to share an office with Mr. Tom Bailey, who was to be my mentor for the next 6 months, and he was to introduce me to the mysteries of property law. However, my promising career in the law nearly came to a shuddering halt because of 2 serious errors on my part. The first was on 24th December, when I was asked to accompany one of the partners to the closing of a mortgage of an oil tanker owned by the firm's most important client, Charles Claw. My task was to take by hand the banker's draft for £800,000 payable to the client to the bank Lloyd's in Gracechurch Street. But not knowing the part of the city, I got lost and I arrived at the bank at 3 5 minutes after the bank had closed. I then realized that there was no point in going back the following day, since because it was Christmas Eve, the bank would not be opening for another 4 days. I mentally calculated how much money Mr. Claw would be losing by way of interest, and that he would be none too pleased. So I rang the bank's doorbell repeatedly in the hope that someone would come. Thankfully, a clerk came, opened the door slightly, and I was able to explain to him my predicament, not only for the client, but also for my future as a lawyer. Amazingly, he agreed to let me in. He took me to the manager, who I persuaded to accept the money and to credit the amount to the client. In retrospect, had it not been for the kindness of the manager and his clerk, I would not be sitting here at the moment. However, my second error was much more serious. A few weeks later, I found myself taking to the cinema a girl I had met the previous week at a charity event. As we were queuing for the tickets, she asked me what I did. I explained that I was a first-year article clerk. She then said she'd been to the theatre the night before with a solicitor, and maybe I knew his name. It was Leonard Sainer. My heart sank, and I said, yes, I know the name, omitting to mention to her that he was the head of my law firm. She was a lovely girl, but discretion was the better part of valor, and I never took her out again. A great relief. Let me now describe the world of solicitors in those days. Strangely, the law limited the number of partners in all businesses to 20. This limit was removed only in 1967. As a result, most solicitors in those days worked in small and medium-sized firms. A 10-partner firm was regarded as on the large side, and there was a large number of one-man firms. The partners and assistant solicitors were supplemented by managing clerks. These were unqualified lawyers who had usually left school at 15 or 16. They had begun as office boys and then worked their way up to specialize in a particular area of the law, usually property or litigation. Some were offered articles without payment, but they had to combine a full working day while studying for their solicitor's qualifying exams. Contrast this with the fortunate article clerks like me, who were given 6 months' leave to prepare for these exams. Low salaries and the need to pay a premium for one's articles largely explain why the legal profession was in those days mostly a middle-class one. And it is largely the same today, with high student debt being the main deterrent, along with a shortage of places for article clerks. Now they're called trainees. My law firm, Titmer, Sainer and Webb, had 5 partners in those days and some 20 other staff. We were housed in an old bank building on Carey Street, opposite the law courts. Some of the partners stand out in my memory to this day. There was Peter Rowley, a keen cricketer, who had on his desk 3 baskets, one marked in, one marked out, and one marked LBW, which all cricketers know means leg before wicket. But in his case, it stood for let the buggers wait, meaning those documents and letters which he wasn't quite sure how to respond to. Another colorful partner was Alan Sainer, who had previously been a rabbi. It was said of him by the late Aaron Owen that he had given up the law of the prophets for the profits of the law. The linchpin of the firm was Leonard Sainer, a man of great ability and a superb draftsman of documents and letters, always pithy and concise. His approach was always that the more difficult the circumstances, the less one should say. Excellent advice. He was unmarried and worked long hours, though not to compare with the hours put in by lawyers today and their associates who think nothing of working through the night if need be. Leonard Sainer was extremely well connected and the main magnet for new clients. Lawyers are frequently divided into finders, minders, and grinders, and I'm sure you can work out what that means. Leonard Sainer was all of these. I'm very grateful to him that I had the opportunity of working with him, as I learned so much from him over the years. I qualified in 1959. Immediately
Charles, your microphone has frozen and your picture has frozen. If you can just stop for a minute. Gillian, if you wait, can you hear Charles? You can. Okay, I'm sorry.
It was coming in and out.
Yeah.
It was frozen.
It was frozen, like you said.
Okay. Okay.
No, what are you doing? Why are you
I'm
muting
trying to
yourself?
get to Charles. Hold on.
Hello.
Charles.
You're muted.
I'm unmuted. Charles.
Don't think so.
Charles, could you possibly log off and then log back on again?
I have her.
I think he's done that. He's not on there anymore.
Hopefully he'll log in. Hold on, I'll phone you.
Ruth is on.
Well, come back in.
No.
Not around the Ruth.
I'm looking. I can't have him. Just email address.
Hi, Charles. You got a problem with your internet? I think maybe the one thing you should try is only having one of your computers going. Maybe Ruth, you should either use Ruth's computer and turn yours off, or turn hers off and use yours. It may be maybe
Ruth
just
is still
using
there.
one connection
Ruth's
will improve.
picture, she was.
I'm sorry? Hello? Ah, there's Ruth.
Just
Okay.
unmute her. She's talking. She
Okay.
can't.
She's muted.
She's talking to you.
Well,
Ruth, you're muted. Ruth?
hold on.
I can't watch on my computer, it's all bad. So I'm going to turn mine off and go and sit with Charles in the other room. Okay?
Okay. Yeah, good idea.
I think he should come here, huh? Because he should have come here because this was working.
She says she can't see.
Apologies, everybody, but we will get over this, absolutely. What a shame.
We'll call him again. We'll see how he's getting on.
Lawrence, tell them to go back to hers. Hers was working.
Yes, yes. Okay.
She said it wasn't working.
Well, she was able to talk to us.
She must have been on his computer. I don't understand.
Hi, Charles. Are you still having a problem logging in? I can't see you.
Yeah.
Oh, there you are. Okay, I'll unmute, please.
There. That's it. Now
Okay,
talk.
wonderful. Okay, Charles.
No, he's muted. He's muted. Ask. Unmute.
You need to unmute, Charles. Unmute.
Okay.
Yes,
Is that better?
yes.
Oh, good. Put it there, Charles. Otherwise you'll look like you're reading the whole.
I think I got up to the point that I was at the University of California. After graduating with an LLM, I then spent 4 months with a New York law firm, where the senior partner was Murray Gerfein. He was a superb lawyer and had been a prosecutor at the Nuremberg War Crimes Tribunal. He always maintained that in any situation, when you are in court or otherwise, if your client is strong on the law, then you hammer away at the law. If your client is strong on the facts, then you hammer away at the facts. However, if your client is strong on neither the law nor the facts, then you hammer away at the table. I could have stayed in the US after my time there, but under the rules of the Fulbright Scholarship, I would either have had to join the American Army or marry an American girl. Neither appealed to me, so I returned to London and rejoined the firm, where I found a warm welcome. I began to build up my own clients, mostly company and commercial, but also occasionally in the field of litigation. One case where I put Gerfein's advice to the test occurred some years later. I was introduced to Daniel, who had just arrived in England from Iran, almost completely penniless and with a wife and children. For many years, Daniel had run a thriving business importing cycles from the UK to Iran, but then the Shah fell and the Iranian economy went into serious decline. The new regime imposed tough exchange control regulations, meaning that you had to obtain official permission to send any money abroad, even to pay for imported goods. The position of the Jewish community also began to deteriorate. Daniel realized that he must somehow build up funds abroad if he and his family were to begin a new life overseas. So he approached his English suppliers, a well-known public company, let's call them Smiths, and suggested that for all future purchases of cycles, Smiths would increase the price by 40%. The agreement was that this extra 40% would be kept by Smiths in a separate account, which Daniel could personally collect if and when he and his family managed to come from Iran. The plan worked well. Smith lost nothing, and the Iranian authorities continued to issue permission for Daniel to pay the price for the cycles, now inflated by 40%. After 18 months, Daniel and his family managed to escape from Iran over the mountains to Turkey, and then on to London. On arrival, he went to see the finance director of Smiths, told him that he had left Iran, and please, could he have the money that had accumulated for him in this special account, and which by then had amounted to nearly £500,000. The finance director responded by saying that he had no knowledge at all of this special account or any such arrangement. Daniel came to me for help. I felt very sorry for him, and extremely angry at the duplicity, the treachery of Smiths. But I had to explain to Daniel that under English law, you cannot mount an action in court that was founded on your own illegality. In this instance, obviously, Daniel had been breaking Iranian exchange control regulations. Daniel was devastated and could not understand why English law would not uphold his claim. So I suggested to him that while Smiths would not be put off by the threat of legal proceedings, they would not welcome the adverse publicity should such a case reach the press, especially as Smiths were supposedly a reputable public company. But it would be a very serious risk for Daniel, since were he to lose, he would have to pay not only his own legal costs, but also those of Smiths, and they could be very substantial. Before issuing a writ, I went to see Ab Kramer, a well-known London solicitor, who was the lawyer to Smiths and who fortunately I knew well. I told him the story and that I intended issuing a writ against his client unless they were prepared to make a fair offer. In fact, Daniel would have accepted half his claim, but obviously I did not disclose this to Ab Kramer. Ab contacted his client. They responded saying that they would make no offer at all. So the writ was issued, and a few months later, the case opened in the High Court. As our barrister was outlining the facts to the judge, I saw Ab's client looking very anxious, especially as a number of press reporters were there taking copious notes. After 30 minutes, their barrister requested a short adjournment. The judge agreed, and their finance director approached me in the corridor of the court and said that Smiths had now decided to make an offer. Emboldened by this surprise cave-in, I said that we had given them the opportunity to settle months ago. And now Daniel and I insisted on our full claim being met, plus interest, plus our legal costs in full, and also Daniel's considerable out-of-pocket expenses. The Smiths team discussed the matter, and to my delight, agreed to all our terms. Daniel, needless to say, was overjoyed. This incident demonstrated to me once more the wisdom of the advice I had learned from Murray Gurfine all those years ago. If you're weak on the law, hammer away on the facts. For me, the biggest surprise and the greatest irony in this story came a few weeks later when the finance director was suddenly fired by Smiths. He got in touch with me, of all people, and asked me to act for him against his old company. What a turning of the tables. Another case with a strong international flavor occurred a few years later. I had a colorful client, let's call him Morris Cohen. He was born in Riga, Latvia in the early 1900s and had migrated to England with his family, where he built up a sizable furniture business. But the family's main asset continued to be one of the largest glass manufacturing plants in Latvia. Unfortunately, this was seized first by the Nazis and then after the war by the communist regime in Latvia. Morris's claims for compensation were turned down by the Latvians, and the UK authorities would not intervene. There were several other UK citizens who were also unsuccessfully seeking claims for the loss of their family assets in Latvia. Then in the 1980s, there was a breakthrough. The Latvian government demanded that the UK authorities should return to the Latvians the £20 million of gold bullion deposited with the Bank of England in London by the pre-war Latvian government. The UK government said no, but eventually a compromise was reached. The Latvians would give up their claim to the gold, and in return, the UK authorities would sell the gold and use the proceeds to meet the claims of the former Latvian asset holders on a pro rata basis. This was welcome news for Morris and others in a similar position. But first, they had to prove to the Compensation Tribunal in England both their legal ownership of the assets in Latvia and also their value. The first was easy since Morris still had the deeds, but how to establish the value of a glass manufacturing plant built in Latvia in the 1930s. Fortunately, working with me on the case was a very bright young New Zealand associate, Joel Zalman Robinson. He had the great ability to think always outside the box. One day when we were discussing the position, Joel suddenly said, if you think glass, you should be thinking Pilkingtons. And he was, of course, right. 2 weeks later, Joel came back to me and reported that all the following had happened. He had discovered that Pilkingtons had an archive of overseas glass manufacturers going back to the 30s. Pilkingtons had given Joel the name of the company which had built the plant. This company, because of the turn of events, had originally been based in East Germany, but the owner had fled to West Germany after the war. Joel had tracked him down and had learnt that when he fled to the West, he had by chance brought with him the plans of the various plants built by his father before the war, including, fortunately, very fortunately, the one in Latvia owned by Morris's family. The plans specified in detail the size of the plant, the number of glass furnaces, and most important, the monthly output. And with the help of Pilkingtons, Joel had calculated the present-day value of the plant. 2 months later, we presented our case to the Compensation Tribunal. Our evidence was accepted and our client's claim was upheld in full. The final tale out of court that I will tell you also had an international as well as a diplomatic flavor. It began frustratingly. It then proved exciting and successful, but sadly, it ended in tragedy. In the early 1980s, the organization known as Lawyers for Soviet Jewry, then run by a young Oxford student called Daniel Tobe, who then went on to bigger and better things, got in touch with me and asked me to represent Boris Chernobylsky, a long-time refugee. He had been sentenced to a labor camp for many years for seeking to emigrate to Israel. He had also lost his job as an electronics engineer. I tried to contact him by phone, but the line was always blocked. My letters to him were never delivered. My persistent letters to the Russian foreign minister and to the Soviet ambassador in the UK, requesting permission for Boris and his family to emigrate to Israel, were always ignored. However, after 2 years of getting nowhere, things changed suddenly and rapidly for the better with the arrival, as you will remember, of perestroika and the appointment of Mikhail Gorbachev as president. One day, I made yet another attempt to reach Boris by phone, and remarkably, he answered. I explained who I was. He obviously had never heard of me, and what I was trying to do on his behalf. And I asked if there was anything specific which I could do to help in the short term. Boris replied, telling me that his daughter Geula, then aged 12, was having an awful time at school, being continually persecuted by both teachers and students. This was because her father, Boris, was well known as a refusnik and as a prominent agitator. I asked Boris how I could help, and he told me that Geula had applied to transfer to the international school in Moscow. This was mainly for the children of diplomats and news reporters, but occasionally Russian children were accepted, provided they could get the consent of the Russian Minister of Education. I said that I would try to help, but honestly, I had no idea what I could actually do to achieve this. It then occurred to me that perhaps the British Education Secretary could be persuaded to intervene with his Russian counterpart. So I sent a letter by hand on my firm's notepaper to Kenneth Baker, the then Education Secretary, explaining the position of my client and asking him for any assistance he could give. This action on my part was done much more in hope than in expectation. But when I phoned Boris a few days later, he told me that lo and behold, Geula would be starting at the international school the next week. I later learned that Kenneth Baker had been due to fly to Moscow the day after he received my letter. He had put my letter in his pocket and took it with him. To the surprise of Kenneth Baker, his visit was upgraded and he was invited to meet President Gorbachev. He gave my letter to the president, and 24 hours later, Geula was told that she could transfer schools. I was completely stunned and lost for words. As for Boris, his situation continued to improve. A month later, he was allowed out of Russia to receive a special prize at the House of Commons from the All-Party Parliamentary Committee for Soviet Jewry. This prize was presented by Michael Heseltine. Ruth and I hosted Boris at our flat here in London, and it was wonderful to meet my client for the first time. It was Stanley Carms of Dixon's who arranged for Boris to buy a word processor. This was the predecessor of a computer. Boris wanted to take one back to Moscow as he knew that he could make a straight exchange for a new Volvo car. On returning home, this is exactly what he did. And 2 months later, when Boris and his family were given permission to leave, he drove the car all the way to Israel. His family flew there. Boris managed to get through all the countries en route without any difficulty, despite having no paperwork. Of course, the Russian authorities had confiscated his Russian passport when he left Moscow. And so he had driven through a network of countries. To each of them, he told his story. He had no paperwork. And the only problem he had was arriving in Haifa. The authorities in Haifa had never known of any immigrant arriving from Russia by car, and they didn't know how to process him. The car was taken off him, and he had to go to Ben Gurion to register there. The car was duly returned to him. Boris and his family settled in very well in Israel, and he was overjoyed at long last to be in the country of his dreams. We kept in regular contact, enjoying seeing his progress and feeling so much pride in the fact that he had, in a small way, contributed to this. One day, however, several years later, Boris went with his family to the beach near Ashkelon. He was a strong swimmer and went into the water, but very sadly he drowned. We were all in shock at this tragic event, remembering all that he had been through before his arrival, and then this had to happen. We still keep in regular contact with his wife, Leah. His son, Yossi, married a couple of years ago and recently had a baby boy. I know for sure that Boris would have rejoiced in knowing his family was so happily established in Israel. These cases represented only a small part of my work. Most of my work was in the field of company and commercial law, where I acted for a large number of leading businessmen. These included Michael Heseltine of Haymarket Publishing, Paul Hamlin of Octopus, Bob Gavin of St. Ives and Folio Books, Robin Hyman of Unwin Hyman, Stanley Carnes of Dixon's, and many others. Interestingly, 5 of them became members of the House of Lords. But much more important, all of them achieved and maintained their success with impeccable reputations. By the way, talking about Michael Heseltine, on the day he walked out of Mrs. Thatcher's cabinet, he had nowhere to go to prepare his resignation speech due to be given in the House of Commons the following day. So he came straight to my office, and Titmuss, Sainer and Webb were able to provide him with all the facilities he needed. And what a speech that was. All of these people became not only clients, but also good friends. They also took my advice to put part of their shareholdings into a charitable trust to benefit good causes. I also became a trustee, and some of those positions continue to this day. One client, Bob Gavron, referred to my advice to set up a trust in this way, saying, if the company prospered, my pocket would not notice the gift to the trust. And if the company failed, it would make no difference. I was also very involved in the charitable trust set up by our client, Sir Charles Claw. This was to finance the publication of important documents from the Judean desert relating to Bar Kokhba, discovered by Professor Yiga al-Yadin. I became a trustee of that trust, and this gave me the opportunity to work closely with Yiga al-Yadin, one of the most interesting and intelligent people I have ever met. And it also gave me a lifelong interest in biblical archaeology. Again, through a good friend and client, this time Stanley Combs, I was introduced to the late Chief Rabbi Lord Jonathan Sachs, and I acted for him in his early years as Chief Rabbi. When negotiating his employment contract, you don't immediately think that the Chief Rabbi has an employment contract, but when negotiating his employment contract with the United Synagogue, I successfully included a provision giving the Chief Rabbi 2 months a year to focus on his writing and lecturing, something which was obviously of great importance to him. This was against all the precedents of employment contracts of previous chief rabbis, and you know how important precedents are in the United Synagogue. Whenever I attended the launch of a new book by Rabbi Sachs, he would go out of his way to thank me publicly, saying that but for me, the book would never have been published. One of the many lessons I learned from Rabbi Sachs is the importance of always saying thank you. However, the clients who gave my mother the most nachas were the Beatles, and especially Paul McCartney, for whom I acted during the turbulent years leading to the breakup of the group. My mother always kept on her coffee table 2 books about the Beatles, each of which was left open at the relevant passage. One such passage referred to a crucial meeting of the group and of all their advisors, which had to be postponed because it was due to be held on a Friday evening. And as the book put it, Paul's lawyer, Charles Corman, an observant Jew, could not attend because of the Jewish Sabbath. The other passage related to a meeting at the Beatles office in Savile Row, which Paul McCartney was reluctant to attend. Instead, I turned up on his behalf, to which John Lennon, always quick off the mark, he commented, "Good to see you, Charles, but where is your guitar?" Looking back on my 7 decades in the law, the following stand out. First, the fascinating clients I have met and the friendships I have made. Next, the opportunity to work with and to train scores of article clerks and assistants who have gone on to become successful lawyers, and from all of whom I learned so much. And of course, there were the wonderful secretaries who helped me over the years and kept me out of trouble. I also vividly remember the Partners Against the Staff cricket match some 25 years ago. I, a rather modest cricketer, was fielding at deep mid-on, and the star batsman in the staff team, Nick Mallett, hit the ball hard and high to the boundary. Putting out my left hand, the ball somehow stuck and he was out. To thunderous applause, probably the greatest thanks that I ever received when I was with the firm. Finally, I should mention that I have never met any anti-Semitism during my career, even though I never tried to hide my Jewishness. In conclusion, I would like to end where I began. On my first day as an article clerk, I received a letter from my late uncle, Irving Goldstein, an outstanding solicitor who tragically died in a car crash, aged 33. After welcoming me into the profession, his letter offered me this advice. Remember, Charles, that a solicitor is not a shopkeeper. To a shopkeeper, the customer is always right. A solicitor who acts in this way will do great harm to himself, to his clients, and to his profession. This advice has stood me in good stead throughout my career, and it has also been of great value to all the young people I have helped on their way. Thank you. And sorry for the minor interruption.
Charles, thank you very much. What a wonderful glimpse into, I'm sure, just a fraction of the tales we'd all love to hear. I'm going to open for questions. I know my wife Josiane has a question for you now, so if you can ask Charles.
Charles, that was absolutely wonderful, and I really could have
Thank you.
very many more stories from you. I mean, having had so many years in the law, you will have seen extraordinary change, whether it changing technology, changing customs and practice, of course, changes in the law. Is there a sort of standout change, you know, looking back, that you regard as having made the biggest impact, maybe whether to you or to the way in which law is perceived?
You're absolutely right. There have been very many changes over the years. The one that stands out is the fact that today there is not the same stability in law firms amongst the partners as there used to be in earlier times. The lawyers very frequently, both as young associates and then as partners, very frequently move from one firm to another, staying for maybe 2 years or 5 years, sometimes more, sometimes longer. But I am one of the almost unique creatures who have stayed with the same law firm over all the years of my practicing career.
Yes. And do you regard that, presumably you do, you regard the fact that there's this much change, movement, as a negative?
Very much so, because it leads to less stability in the firm and to lawyers thinking more about their own personal position, how they can advance their position, rather than necessarily concentrating on the interests of their clients.
Absolutely. Thank you.
Anyone have a question? Put your hand up and I'll unmute you, or unmute yourself and ask a question. Going across. Tom? You unmute.
Thank you, Charles, for a fantastic talk. Wonderful career. And knowing you quite well, it makes me wonder, what would you have liked to be if you couldn't be in the law?
Ballet dancer.
Ruth is standing next to me and she said a ballet dancer. That I think would be that would be much too modest an ambition. Tom, never thought of doing anything other than becoming a lawyer. So that really is a very theoretical question. I remember when I was a 7-year-old, I used to read all the law reports in the newspapers. They were usually lurid murder cases. Matters like that I never dealt with, but it never occurred to me to do anything else.
A gardener.
Thank you.
Thank
Tom.
you.
Thanks.
Anyone else with a question? I'm just going to switch screens and up there.
I would like to say, I'm glad that cousin Charles sent me the link, because I found it really, really interesting. I worked for Alan Novery for over 10 years, and I ended up in the Middle Temple working for the surveyor. So I do feel I've got a connection slightly, not the qualifications, but I found it very interesting. And of course, I lost a very talented stepson, Charles Blake, in September, who was a well-respected in every aspect. Anyway, that's it.
Thank you, Margaret. Charles, although a lawyer himself, occasionally sought legal advice, and he came to me, and he was one of the nicest and finest clients I ever acted for. Thank you.
Charles, can I ask you, I know Ruth is a prolific writer. Have you ever put your tales down into a book? Any thoughts of doing that?
I haven't for two reasons. First of all, I spend so much time editing Ruth's literature of her tales. But the main reason is that there is a limit to the amount which, as a lawyer, I can disclose about the affairs of my clients. And in the stories that I've told you, you probably guessed, I've changed the names and changed a number of the facts so as not to give away any client's confidentiality.
Actually, I can confirm that, because Charles and I have been married for 38 years or so. He's never ever once told me what he did at the office. And I actually didn't think he was a lawyer. I thought he was probably a spy for Mossad. Never talked about it once.
Very nice. Anyone else have something to ask Charles before we sign off? Laurie.
Charles, hi, it's Laurie. Wonderful, moving talk, Charles. Thank you so much. I wonder if you have any times when you had regrets about advice you'd wish you'd given but didn't give?
Yes, but since it means disclosing the details of the client, I think I'd rather not mention it over the Zoom.
Anyone else before we sign off? Coming up to mid. David, can you unmute? David Rose.
How have you coped during lockdown, Charles?
Probably as well as you, David. No, thanks to Ruth, we have a wonderful garden. I spend a lot of time gardening. And in comparison to the position of other people, we've been very fortunate.
Okay.
Thank you.
Gillian, do you want to have the final say before we log off from this series?
I think we can say that both of us have enjoyed doing the series, and it looks like quite a lot of other people have enjoyed us doing it. And we will be back. We promise to be back. We're going to do some other things, hopefully meeting together when that's allowed in the summer. And Hag Sameach to everyone.
Hag Sameach, and thank you for everything that you and Lawrence have been doing.
Hear, hear.
Here, yes, Hag Sameach. Thank you very much indeed, Gillian and Lawrence. It's been a really fascinating few months.
Thank you.
You're welcome.
Thank you, Charles. That was a wonderful talk.
Really special.
I'll miss the Sunday morning at 11 o'clock and my cup of coffee, but it's been wonderful. Thank you.
Thank you, Charles. Chag Sameach.
Thank you.
Thank you.
Thank you very much. What am I going to do Sundays at 11 now?
We can have a cup of coffee together.
Yes, good. Best wishes, everyone. Thank you so much. It's been marvellous.
Bye.